that's too bad. That's
Yeah.
too bad. Is his travel team over too?
Yeah, his travel team is over. His travel team is over. There are still other teams that are still playing, but his team is done. So he finished second in the States. They finished second in like the last 3 tournaments they played in, you know, traveling around.
Do you and Lori go to most of the games, or the weekend games?
All,
Or do
we
you?
both travel with him.
So you eating at some Denny's this year?
Proud of you, man. We were in Chicago in January. That was fun.
Wow.
Yeah.
Oh, it's good for him though, man.
It is
for
good.
him.
Yeah. But well, you probably never met, but he's taller than me now.
Is he really? And his head is fine.
Yeah.
That's just a horrible.
My
every
kid
time.
had a bad. Well, he's had a couple concussions, but he had a bad concussion at a ski resort last year in Colorado. We told we actually took the time to tell the instructor that the kid plays a lot of hockey. He's going to be very good on his skis, but he's snowboard. He doesn't know how. He's also a high level skateboarder. He doesn't know how to ski. He doesn't do it. Don't let him do anything dangerous. So the ski instructor said to himself, "Oh, he looks so good. Let me take him off a ski jump." At the end of his first day, the kid falls, cracks his head.
Was he wearing a helmet?
He was, thank goodness, but still, he has no recollection of the accident, no recollection of the ski patrol taking him down the mountain, no recollection of the trip from the medical center at this mountain down to the town. He did not recognize my wife. Somewhere in his brain, he knew her name, and he said, "Call Lori Herzog, call Lori Herzog," and she was standing.
Yeah, as ready as I'm gonna be.
It'll
Yeah.
be a few minutes.
We're gonna start in a few minutes. Could I just remind everyone to please turn any kind of noise-making device, a cell phone, a pager, whatever, to silent.
Very scary. Yeah.
All rise. The Court of Appeals Division 1 is now in session.
Good morning. We're here today in Fuqua versus Dollar Tree Stores. Our cause number CACV120720. These proceedings are being audio and video recorded, so we'd ask that you please Identify yourself and your client at the beginning of your argument. Each side will have 20 minutes, and appellant's counsel is responsible for managing the clock to reserve any time you may wish for rebuttal. We have read the briefs and we've conferenced this matter, and we're looking forward to your argument. With that, counsel, you may proceed.
Good morning, Your Honors, and may it please the Court, my name is Scott Boehm, appearing today as appellate counsel for plaintiff Bridget Fuqua. We're seeking today from the Court a new trial on the issue of damages, and depending upon whether the Court agrees with us on one of the liability issues, the remand may include, or may need to include, in our view, a new trial on all issues. And I'd kind of like to start, if I could, this morning on the liability issues. Generally, I think we are entitled to a judgment as a matter of law on the issue of Bridget's comparative fault. And the reason for that is because there simply is no evidence in the record that she was either negligent or did anything wrong or could have done anything any differently to avoid this fall at Dollar Tree. Now, I understand this is a sufficiency of the evidence issue, and although the Court's review on J-Malls are de novo, you're going to defer to the jury's verdict in terms of how you view the evidence, and we acknowledge all that.
Counsel, aren't there at least a couple of pieces of evidence at play, arguably at least, that the notion that the plaintiff had been to this store and even into the restroom on prior occasions, correct?
Right, yeah.
One piece, and then that she was aware that the door was heavy, and that she had been told or advised by at least one physician to have a walker, or use her walker or cane.
I think, I'm not sure the latter is correct. I think that the evidence at trial was, first of all, I agree completely. That's their 3 points.
Okay.
And I'll address them sequentially if you wouldn't mind. With regard to using the bathroom previously, my view of that is so what? There's no evidence that when she used it, if the door was in the same condition at the time she used it previously, or that she did anything, could have done anything differently on this occasion. The question of whether the door was heavy going in, and Bridget even acknowledged that, it seemed heavy going in. The only expert who testified on this was our liability guy. His name is Brent Beals, and his position was, his explanation as I don't know if he's an engineer or a door builder or whatever the heck he was, his undisputed testimony was that the fact that the door was heavy going in would not have given anyone other than a door installer or a mechanical engineer any indication that it was going to slam shut going out, because the door itself wasn't the problem. It was the lost closing mechanism that was the problem. And so there was no indication, and I'm not even sure there's any argument from the defense at trial that Bridget would have known that it was going to close any quicker. With regard to the cane and walker, she didn't really need it back then. That was Bridget's testimony. This was, keep in mind, this was 7 years after her 1999 back surgery. And she had been doing pretty well, especially after she went to China in 2004, I think, and got the stem cell treatments. So she was able to walk on her own and drive and get around and do her shopping. If she had, and there's no question about this, and I'll concede this for you, if she had to walk longer distances or over uneven terrain, that was when, at that point in her life, she needed the cane or walker. But just driving to the store and walking around the store, she was fine at that point, and that was the evidence on that. This is
Counsel, on that point,
No, go
was
ahead.
there any testimony or any evidence that, did anyone opine that when the door closed, that the presence of a cane or walker would have allowed her to catch herself.
No, and I think that's ultimately my point, is they didn't, not only did they not have that evidence, they didn't even try to present that evidence. They didn't have really any liability people at all to say that if she had a walker or if she had a cane, if it would have made any difference at all. They argue in their brief that she should have been more reasonable. I'm not sure how. It was a handicapped woman using a handicapped restroom, and there's no suggestion, even speculative, what she could have done differently to avoid this injury, which of course is amplified by the fact that they lost the closing mechanism. So there certainly would be a point at which this thing, and I don't know if that was the case here, but that's the point, we don't know. There was a point at which this closing mechanism could have been so out of whack that it just slammed shut, and there's nothing she or any of us could have done to avoid it. We don't know if that was the case here, but that's our spoliation issue. This is the closing argument, and this is the entire, their entire position on this comparative fault. And this is Mr. Herzog's closing, April 12, 2012, page 177. All we're saying is, look, she's been there a lot of times before. She knows the door is heavy. She knows she's got all these physical problems. And we say, should she look out for herself a little bit? You might say, no, you're full of beans or something. Okay, you say that, you say that. But that's what this case is about, and that's why there's a line on that form, the verdict form for Ms. Fuqua, for you to decide, should she have been more careful? Did she act unreasonably under the circumstances? And if you decide that she did, whether you think that under all of the circumstances of the case, that should reduce the amount of money you reward to her. It's your decision entirely. That's their whole case.
That's their
And
whole
the-
closing, but can you get back to the third point? Because in my view, that's the one that's the closest to sending this issue to the jury, and that's Dr. Jasser's testimony, that he told her prior to the incident that she was at an increased risk for fracture due to her severe osteoporosis and should use a cane or walker. Why isn't that enough to get the issue of comparative fault to the jury?
Because I don't think, because Bridget explained that she didn't need it all the
No,
time.
I know she disagreed, but Dr. Jasser gave that testimony, so why isn't that enough? Even if it's thin, why isn't that enough to go to the jury?
Because I think, I think it's because it's so bare, it's so threadbare testimony. And I, to be honest with you, I'm not saying it's not there. I don't even remember that testimony. So it may have been mentioned in passing, and it may have been discussed in more detail, as the court's pointing out there. But it was so minimal compared to all of the other testimony that I think it would lead to speculation here. The more important issue on this point, and I think this, if you don't agree with me on the J-Mall, if it goes there, we have two backup arguments, which unfortunately necessitates a retrial on liability. One being the fault allocation, 75-25, which I'll get to that in a minute. But I think the bigger one on this is the spoliation issue. And the dispositive case, of course, is Judge Brown's McMurtry opinion from about a year ago now. There's no doubt that...
Counsel, just to cut to my concern about that case is, in that case, the request was for a jury instruction to draw an inference, an adverse inference. Isn't there a significant distinction here where the remedy sought was complete, taking away the comparative fault?
Yeah, I have two responses.
Aren't those quite different?
Well, they are quite different. But I do think it is significant that no one objected to the substance of the instruction. The only debate at trial was whether this instruction should be given, not whether it was substantively correct. And I'll agree with you. When I read that instruction, I thought, I'm not sure this is the law in Arizona. But McMurtry has the law, and the law is that one of the available sanctions, I'm reading from your opinion at paragraph 52, is to instruct the jury that it may infer that destroyed evidence would have been unfavorable to the position of the offending party. Now, although that instruction wasn't proffered that instruction clearly should have been, or certainly could have been given, because the trial court has an obligation to instruct on the law, and that's the law.
It doesn't have an obligation to rewrite instructions. That the parties proffer, it's just required to accept or reject the instructions offered to it. So
Well, and-
you're
and-
suggesting that the court should have sua sponte said, well, I won't do what you're asking, but I'll do something a little different, and it's this? Is that?
Well, I mean, and if, I guess if it's an either-or question, excuse me, then he should, then, I don't even remember if it was a he or she, the trial court should have given the instruction as proffered, because there was no objection by the defense to the substance of the instruction. And I think, I think the reason the instruction was given in written the way it was, basically taking away the defense of comparative fault, is because this was the dispositive key piece of evidence on that. I mean, because as I talked a little bit earlier, there was, at some point, this door could have been slammed so hard, so fast, that there's nothing that anyone could have done. And we were precluded from doing the testing on that. Yes, their guy tested it. Yes, they came up with the idea that it closed 3 times faster than it should have. But we shouldn't be stuck with that. And it's not, and this is one of their, this may have been their only argument at trial, and it certainly is on appeal, that the spoliation issue and no instruction of any kind should have been given because they admitted liability for the defective thing. Well, that misses the whole point, because I mean, if we win on Jamal, then it's no big deal, because her alleged fault is out of the case. But if based upon that one bit of testimony, if you all decide that there is a small question of fact, if we can call it that, and that comparative should have gone, then it's a main issue in the case, because the jury should have been allowed to, or been instructed on the spoliation issue, that we were precluded from proving that they were 100% at fault, and that there's nothing Bridget could have done with a cane or without a cane, or with a walker or without a walker. So just to wrap up the spoliation issue, their argument is that since the defendant admitted liability, their own liability, that spoliation was unnecessary because they admitted it was negligent. The problem is not that, and that's not the unfavorable to the position that they're taking. The position that they're taking, that this would be relevant to, is Bridget's comparative fault. And that's why, even if you disagree with me on the Jamal issue, that this should go back for a new trial on liability. Now, the other question, and I've got 7 minutes left, I want to save a little bit if I can, but the other question on the allocation of liability is the Hutcherson and Stiles issue of the 75%, 25% allocation of fault. And even, I think, Judge Downey, if that statement by whatever doc you identified there was good enough to get to the jury on that issue, it still, I don't think, tips the balance. And this, again, is a deferential standard. I'm conceding that right up front. It still doesn't allow, I think, based upon the totality of this evidence, the jury to come up with the idea that Bridge was 3 times more at fault for causing this fall down than Dollar Tree.
But why not? Why couldn't the jury, assuming the jury believes that she should have been using a walker, why couldn't they conclude if she had been using a walker, she would not have fallen?
Because that's pure speculation. There's no evidence in the record, and I think Judge Downey said that, but it might have been Judge Brown. There's no evidence in the record that, and they didn't even try. So this wasn't a disputed issue at trial. There just is no evidence that using a walker or a cane or anything else would have made any difference.
Isn't the evidence that a doctor had told her that she should use a cane or a walker, isn't it just kind of the underlying assumption that will make you more stable?
No, and I think that goes against the Acuna versus Croak principle, that you can't speculate as to negligence or unreasonableness of conduct, because we don't know, and this is the real big, pardon the pun, fall down on their theory, is the fact that we don't know if it would have made any difference. And we couldn't find out if it would have made any difference because the closing mechanism is gone. So these three issues kind of dovetail. I got 5 minutes left. We raised a lot of issues in our brief. The first 7 were all evidentiary issues, omission of fact. They kind of get all distilled down to this lack of foundation thing. And I briefed the heck out of that. I don't want to waste a lot of time for you here today. But what I think happened is we had a relatively inexperienced trial judge who just got overwhelmed with this issue and got off on this idea that the expert had to actually see these falls occur, and there's just no law to support it, and the trial became a fiasco. I don't know if you've read the transcript, or your clerks probably have by now, but it got ugly. And from our perspective, trial counsel went from frustration to desperation, and the trial judge, to his or her credit, I guess, stuck to his guns. And once he said that, at Mr. Herzog's urging, that these experts didn't see.
Counsel, to that point, I mean, on the issue of whether the court was right or wrong on the foundation rulings, what about the issue of prejudice? Because it seems like, from what I've read, which I'm not going to represent you, I've read this whole transcript, but from what I've read, it seems like a lot of evidence did come in through Dr. Heath and through some of the other doctors, that Dr. Heath was able to keep going and keep expressing her testimony about the fact of the significance of the hip injury, and that it led to future problems. Is that not true?
It's not true. What is true is Dr. Heath and the other docs as well testified at length about leg buckling and the problems with the hip healing, but the surrounding tissue not healing, and that leads to falls, and that was expected, and this is just what happens. They talked a lot about that, so to that extent, you're correct. And he also, Dr. Heath, was allowed to, her trial exhibit 115, her ultimate opinion came in that, and this is, I think, what you're getting at, what's the prejudice if the opinion got in. I believe the health problems Ms. Fuqua has encountered since February 13, 2006, and are discussed in my report, are causally connected to her injuries she suffered on February 13. That itself got in, and that takes, right there, I think, takes care of the whole foundation thing. But what she was precluded from explaining, I mean, that's a nice little sentence, but what does it mean? Why
But
do
she
you
did
think
go
that?
much further, as Judge Brown pointed out. She testified that the lack of recovery from the hip fracture contributed to the subsequent falls, accelerated her osteoporosis, caused deformities of her upper body, changed her gait, negatively affected her balance. She testified, as I've read it, quite at length about how the hip fracture caused these subsequent problems.
And believe me, every time she even kind of sort of said that, I put it in my brief. So if you're getting that from my brief, that was in the record. But she didn't get to explain what she meant by it. And every time, and Mike, there was a lot of falls. I think there were 8 falls afterwards, and the scoliosis that we wanted to tie into this thing, and that Dr. Heath did tie in. So every time, rather than just say this one sentence, trial counsel here wanted to go through the May 2006 fall, which was 3 months after the broken hip, and tie that specifically based on buckling and the foundation on buckling, and it was caused by her leg buckling. That was all in there, and that's, I think, what you're talking about. So all that came in. But when it came down to the opinion that was the May 2006 fall caused by buckling, was that caused by the broken hip? Mr. Herzog got up and said, she didn't see this. She can't say that. And he even went so far to say that statement in the report is one thing, but she can't, the explanation of her report is an entirely different thing. And that's what the court bought. And he bought it again and again and again and again. And it just became almost a circus through the trial. And Mr. Herzog, to his credit, I guess, as the defense lawyer, laid it on really thick with his objections. And I think the trial judge was kind of getting, sick of hearing about it too, because plaintiff's trial counsel, he tried it with Heath, didn't work. And you can see his case going down, because this was the key to the whole damages case. I mean, this Dr. Heath's testimony tying all these subsequent falls, because the hip healed.
So Heath is the doctor, because you only get one expert per issue. Heath
Right.
is the doctor. Had you been permitted to provide this expert opinion about cause of future falls, Heath would have been the expert.
Yes, and then all of the other ones, I mean, trial counsel tried to, he tried it with Lee, he tried it with
That's
Hofstad.
because Heath was
Exactly,
precluded.
I mean,
Had
yeah,
Heath been allowed,
absolutely.
you wouldn't have been permitted to elicit
Yeah,
those
they don't,
opinions
yeah,
from
you don't
others.
get four people up there saying the same thing. I'm down to 18 seconds, I might as well finish up and sit down here. All of the other experts, the issue is kind of the same because the lack of foundation issue carried through to all of them, but as Judge Downey pointed out, if we win on Heath, it kind of sort of becomes moot. I think they agree in their brief that if we win on the causation testimony, that takes care of the issue with Loretta Lukens because her foundation would have been admitted, and same with the present value guy whose name I think was McKibben. So it's once Heath's opinion and on the report and the foundation outside the report ultimately takes care of all these other cascading issues on lack of foundation, and I'm out of time. Thank you very much.
Good morning, Your Honors. Eileen Gilbride and Michael Herzog with me for Defendant Dollar Tree. I'm actually kind of shocked that Mr. Boehm went off on causation and spoliation, or not causation, but comparative and spoliation, because I didn't think those were his good issues at all. I still believe that, as Your Honors have noted, on the comparative, there was plenty of evidence to go to the jury. She knew the door was heavy. She had been there before. She testified the door seemed the same as it had been before. She had been warned about her propensity to fall. And that's what Dr. Jasser had said. You have the propensity to fall. You need to be very careful about what you do. And yet she went in there anyway. It's not so much that...
So let's explore this a little, because I'm concerned about it. But the heaviness of the door,
Yes.
What should that have put her on notice to do differently?
either not go in there because she didn't have her cane or her walker with her, or
But let's just cut right to that argument. What testimony or evidence ties the lack of a walker or cane to falling, other than common sense? I mean, let's put common sense aside
Right.
here for a second.
Right.
Because I don't know.
right,
what-
and there isn't
What evidence could the jury draw from to make
There-
that inference?
Right. There is not evidence that had she had a cane or a walker, she would not have fallen. But then again, plaintiff didn't raise that argument below. He didn't say the reason that we're entitled to judgment as a matter of law on comparative was that this evidence was lacking. So that's a new argument that's made on appeal.
But did, on the counter to that, did you say that there is evidence in the form of she was not using her cane or her walker? I mean, in response to wasn't there a motion for summary judgment filed on this, like, early on in the case?
There may have
Did you?
there may have been, I don't recall off the top of my head, but
Well, I guess I'm just asking the counterpoint. They moved for JMOL, and in the little blurb in the transcript, it didn't look like Mr. Herzog responded with the argument she wasn't using a walker or a cane.
she should have known not to go in there, not to use the door if she knew that she was had a propensity to fall.
Right.
She knew from the doctor she had to be careful. She knew that door was heavy. It was the same as before, and yet she decided, I don't have my walker or cane, but I'm going to go in there anyway.
I thought that the emphasis of the JMOL motion was to focus on causation, so the causation, and that's what the court was trying to struggle with. I think, what was the causation? What caused her to fall? Was it the lack of a walker or a cane?
Or the fact that she went in there knowing that the door was heavy and that she had a problem with it. Not that she had a problem with it before, but she knew that door was heavy for her. I mean, she could have decided, I have to be very careful. That door is heavy. If I go in there and I don't have my steadying devices, that could be a problem for me.
Were you able to come across any, and perhaps you cited them, and sorry, there's a lot of briefing here, but any case law that's at least somewhat on point where there's an admission of liability, and then the person is, this issue of causation as to comparative fault? Can you draw any now? Even if you don't have case law, can you draw an analogy? Is there an analogy to seatbelt use? Is that analogous in any way?
Or you get into the car knowing that the driver is not safe. Don't get in the car if you know the driver is not safe, regardless of whether you have your seatbelt on or not. You have to watch out for yourself. And the jury obviously believed 75%, 25% that she knew that she was frail, and if she was going up to a heavy door, that maybe she ought not to do that.
Let's talk about that allocation, because I tend to think there was enough to send the issue to the jury, but the allocation gives me some pause. If it were flipped, different story, but what in this record would support allocating so much fault to her and so little to Dollar Tree?
Well, Your Honor, it's the same thing. I lost that issue in Hutcherson, and I thought the same thing as you. How could they ascribe 75% fault to the 911 operator and only 25% fault to the guy who went up and shot the lady? And the court said, you know what, the jury is well equipped to decide that had the operator done what she should have done, the bad guy wouldn't have gone up and shot the victim. Here, had Miss Fuqua not gone into the bathroom, and put herself in the position of being unstable and not knowing that the door was heavy, maybe she wouldn't have, had all the problems that she had. This is really it's a jury decision, and we're not here to substitute our judgment for them.
But it's almost as if once the issue goes to the jury, we're stuck with whatever they say. If they'd said 99%, 1%, I'm not completely comfortable with that concept.
I wasn't comfortable with it in Hutcherson either, and the court disagreed with me. I feel like now I'm on the other side of things, and if we have to live with the goose, we live with the gander as well. As long as there's evidence to get to the jury, and there was certainly, then the jury is entitled to decide. They're entitled to say, you know what, you're really overreaching here, Ms. Fuqua. We feel sorry for you, and we understand that the mechanism was out of code for the ADA, and we admitted liability for that, and she was knocked down, and we admitted that she should be compensated for the hip and for the rehabilitation and all of that. And maybe the jury was saying, you know what, people, we think any more than that, you're really sort of overreaching. You should have been more careful and not gone in there knowing what you know about your substantial problems going into
What's
this.
the alternative if you have to go to the bathroom? It's kind of an odd choice.
Well, yeah, then you bring your walker, you bring your cane, you decide, you know what, I'm going to go to the bathroom before I leave the house, and make sure that I'm going to go use a restroom where I feel more comfortable with the door.
There was an interesting there were a lot of jury questions, which was unusual in my experience, but one of them asked Ms. Fuqua, how long had you been in the store at the time you went to the restroom? Is there any context for that question that you're aware of? Or
I honestly don't recall the question, Your Honor, and I guess that would be interesting to know if she had spent 6 hours sort of wandering around, or whether she had gone in knowing, well, I might have to go, but I don't know. I really don't remember the question or when it came about.
Counsel, how does prior awareness of the door necessarily support comparative fault when she hasn't been? I don't know if she'd been there one time or 50 times before. I don't know if the record reflects that, but the door never hurt her the prior occasion.
But she knew it was heavy. And she said the door on this time didn't seem any different than any other time. And she knew it was heavy. And she knew she had to be careful. And the doctor had warned her, you are at a risk of falling. And so, and obviously, she had such substantial problems before this day. pain 10 out of 10, and all of the things that she said in her Social Security disability application, she certainly should have known that she was at risk. If you are done with questions on the comparative and the spoliation, I guess we could go to spoliation just for a minute, even though I don't think it's a very good argument on their part, because their expert never testified that he needed the mechanism for any reason. He didn't need the mechanism to give his opinions. There was no testimony about that, so I'm not sure where we get with spoliation. Certainly, this is an abuse of discretion standard, and the trial judge was certainly within his discretion in not taking away comparative fault when the expert never even testified that he needed it for some reason. I'd like to talk about causation for a minute if the court is interested in that issue. Again, we remember here that the standard of review on the admission or rejection of evidence is for an abuse of discretion. So again, we're not here to substitute our judgment. I think it's pretty clear that doctors Hofstedt, Lee, and Sellers had absolutely no knowledge of her condition before the accident. They didn't even see her till after the accident. So there is no foundation for them to testify that her post-accident condition or falls or anything was related to her pre-accident condition, because they didn't know about her pre-accident condition.
And on that point, I don't want to discuss Ms. Lucan's report in any depth, but she relied on Dr. Lee.
Exactly.
Okay.
Exactly. And he didn't have the foundation, so that was an improper foundation for her to rely on. You may be asking, well, what about Dr. Heath? You know, her report said, I think her current medical problems are causally related. And as Judge Brown, you noted, the trial judge was very lenient, and Judge Downey, you said this too, was very lenient in letting her testify to her causation opinions, even though she didn't know how the subsequent falls occurred either. No one did.
So why were the, how do I ask this? Why were there continued objections and apparent sustained objections, and yet the testimony appeared to still come out?
Well, because what the objections were testimony as to why the subsequent falls occurred. The plaintiff's counsel kept asking, so did this subsequent fall occur from the accident, or was it, pre-existing?
Wasn't that the conclusion of her report, Dr. Heath's report? In that
No.
one sentence, it said...
Her report didn't talk about subsequent falls. It talked about her current medical condition. It said nothing about falls, and that's why the trial judge prevented her from testifying that the subsequent falls were caused by the accident, because we don't know. I mean, she was leaning over the bathtub. We don't know if she was on one foot, she's on both feet, she's twisting this way. There's no evidence whatsoever. She goes to sit on a computer chair, it rolls out from under her. No one knows exactly what happened, sort of biomechanically.
Didn't she explain what had happened?
She said on a couple of occasions what she felt. My leg gave way. But also, but just because a lay person testifies, my leg gave way, doesn't mean we know how biomechanically the fall actually occurred. I mean, she went to sit on a rolling chair, it rolled out from under her. She said, oh, my leg gave way. We don't know we don't know if she was sitting on her right leg, her left leg, if she was on 2 feet, if it was her ankle, her knee, her hip, her toe, or if it was none of those. We just don't know.
And Dr. Brown, the defense expert, was not permitted to testify as to those specific mechanics of later injuries.
Yeah, in fact, and I believe my answering brief misspeaks on this at page 10. There's an error in my answering brief, because it talks about him testifying to subsequent falls. He didn't, because no one asked him. Defense counsel did not ask him, so what caused the subsequent falls? Because he didn't know either. No one knows. All Dr. Brown testified was that her current conditions were pre-existing, not that the subsequent falls were related or caused by the accident. And so Dr. Brown didn't even testify to that either. So basically, Dr. Heath and Dr. Brown were allowed to say the same things on causation about her current medical condition. Okay, I think they're related. I disagree. I don't think they are. But no one could testify, and Judge Herod was very watchful of this. He didn't allow anyone to testify what caused the subsequent falls because no one knew how they actually occurred. And that was right down the line accurate and correct. I honestly commend him for being so on top of that issue. And Judge Brown, you're absolutely right that Dr. Heath was given a huge amount of leeway to testify about her report, about her current, the current medical conditions. But the judge, again, did not allow her to testify what the subsequent falls were caused by because no one knew. And that's completely accurate. And of course, since no one knows what caused the subsequent falls, Ms. Lucan's life care plan couldn't come in because
Why couldn't that be the subject of cross-examination? Let's say someone just doesn't have a memory of something that happened. I mean, isn't it something, if they relate that to a doctor, can't the doctor just opine that continuing weakness in a hip?
They did. Continuing weakness. A couple of doctors, Dr. Lee and I believe Dr. Hofstedt, both testified, yeah, she fell because she had continuing weakness. But you can't say, but neither Dr. Hofstedt nor Dr. Lee knew what her pre-existing condition was.
But just focusing on Dr. Heath, if she wanted to testify that the subsequent falls were related to the weakness in the hip.
And she may have also testified to that. Or that her current conditions were related to weakness in the hip. Let me get her testimony real quick.
But she's precluded specifically from saying
The
related
falls.
to, for example, a treadmill fall, or some of these subsequent falls where these objections are being raised. They're saying, well, you didn't see I wasn't completely clear if it's the expert, you don't know exactly what happened on the treadmill.
Right.
Or was it that they hadn't been told by Ms. Fuqua what had happened, or just that you don't really know what happened?
We didn't know the mechanism. No one knew the mechanism of the fall. She says, I was trying to get off. I hit fast by accident. My leg buckled. We don't know if she hit fast by accident and then she fell off and then her leg buckled, or if her leg buckled and then she hit fast, or we just don't know exactly what happened. And if we don't know what happened, we can't say what caused it. She hit fast by accident. She fell off the treadmill. She says her leg buckled, but we don't know what caused which. We don't know which.
Is that the real issue? See, because I thought I heard you say that several doctors said continuing weakness in her hip was a cause of the subsequent falls, but what they couldn't say is that she wouldn't have had the same hip weakness absent the Dollar Tree fall. Maybe I misheard what you said.
I believe they testified that the weakness made her more susceptible to fractures.
Right.
Not that, I don't believe they testified to what caused her subsequent falls, because no one could testify what caused her subsequent falls. They testified she had hip weakness that made her more susceptible, but we still don't know what caused her to fall. Like on the chair, she was a rolling chair, the treadmill. She fell at El Torito because her walker got caught in the crack. That was one of their subsequent falls. No one said that had anything to do with her accident. So there really was no foundation for anyone to testify how the subsequent falls occurred. I know, Judge Downey, you don't really need to hear about the Lucan's life care plan. If either of the other you judges would like to hear about that, it was completely appropriately precluded for several reasons. First, and again, the life care plan relied on Dr. Lee's records, and Dr. Lee had no foundation to know what caused the subsequent falls. And yet the Lucan's report, right up front, first page, says, I think, all of her care is and her subsequent falls, all of her care that she's going to need in the future includes that for her subsequent falls. And of course, there was no foundation for that. In fact, she said outright in her deposition, and this was attached to our motion in limine, that the life care plan was based on the assumption that the subsequent falls were causally related to the accident. Well, she had not only no foundation for that, but she didn't have the qualifications for that. She's not a doctor, so she had no foundation and no qualifications. So, I mean, for 10 reasons over, the Lukens plan was appropriately precluded. On the rest of the issues, I think we've covered them. If the court has any other questions, I'd be happy to answer them. All right, thank you, and we'd ask you to affirm.
Thank you for your arguments, counsel. We will take this matter under advisement and issue a decision in due course. Thank you.
Nice job, Scott. I'm sure we'll be seeing you. Don't answer that question.
Thanks a lot, man.